This is Dance Studio 411, where we answer your real-life questions about your toughest studio life predicaments. Parent problems, teacher turnover, student challenges, policy dilemmas, and so much more. Let's talk about what's keeping you awake at night and what you can do about it. Here are your hosts, Suzanne Blake Garrity and Jill Tyrone.
Welcome, everyone, to this episode of our Dance Studio 411 podcast. Jill and I are here today to talk about a kind of a tricky subject, aren't we, Jill?
It is very tricky. I think we're going to get a lot of questions and give some great information today.
Good. I know. And we generate so much of our episode content off of our members and our listeners' questions. And, you and I both know, and all of our listeners know, this is a unique industry. We have so many beautiful traits and we have so many complex parts that we have to navigate. So I'm going to let you kind of share why we chose this topic today.
Yeah, we have so many studio owners and even some teachers that come to us because they don't know who owns their choreography. They're not sure of what happens when maybe a teacher suddenly quits and they want to go and take their choreography with them. It's a really muddy topic because we don't know where that line is. Do we, as the studio owner, own that choreography? The teacher that's leaving, is it their choreography? Can they just take it with them and put it on a new competition team or at a new studio? So we're going to dive right in. We're going to get into some very legal terminology and legalese and things that have been proven through the court system. So we have that, but we're also going to just give you some very practical advice as well. But we have the actual court cases and things to back it up.
Exactly. And of course, this is our legal disclaimer. Always consult with your attorney should you have questions, because we recognize that no matter where you are, maybe your state has different laws, or, you could be anywhere in the world. So again, use this as information to empower you and to be more informed. And always, if there's more questions, take it to your team. So
use this as a guideline. And then if you have further questions, consult your attorney for sure.
Exactly. So let's get right into it. Who owns the choreography? Mm-hmm. Basically, your studio may own the rights to that work if creating choreography for dances was part of the scope of your dance teacher's job requirements. And if the dances in question were actually created during their time of employment at your studio. So that means, was the dance teacher required to create dances? I'm going to use recital routines or even competition pieces for that matter as part of their job description while being paid as an employee. Because there's an exception to the general rule that the person who actually creates a work is the legally recognized author. It's referred to the work for hire doctrine, and we're going to get into this. So there's a distinction between the authorship of the work and the ownership of the work.
Okay, let's make that distinction because this is already, I can see it. It's a confusing matter. So let's talk about the author versus the owner.
Exactly. And that's what we're gonna get into here. I promise you, your head will not spin at the end of this. So we're talking about United States copyright law. Okay. It states that if a work is made for hire, then the employer, not the employee, is considered the author. Let me repeat that.
Awesome. Yeah.
So under United States copyright law, it states that if a work is, quote, made for hire, then the employer, not the employee, is considered the author. Interesting, right? So,
right. So what's considered made for hire then? Let's maybe define that.
Exactly. So work for hire is that you're saying, I'm hiring you, I'm paying you to do a job, and part of your job is to create this work, this deliverable, so to speak, the dance, the recital routine, or the competition piece. And so it's tricky, right? It's like I'll give examples. If you work at a marketing firm and you're a graphic designer and you're an employee, and let's say you come up with the most compelling tagline for a major product, you're basically work for hire. You don't get the right to earn the residuals off of that work. Okay, it's part of your job, and you've basically given it to your employer. They're the author. A good, great story of that goes back to the Nike logo. The original creator of that logo, I think, was paid a minimal amount of money. It was a work for hire, and she delivered that logo, and never again will she see royalties off of that because the employer is technically the author because they paid someone to do that work for them.
Exactly. So those are great examples. And I think about it too with a lot of the work that I have done over the years, working different law firms, marketing firms. The work that I've done, I walked away from it when I moved on and was no longer at that firm. So it is definitely a good distinction when you think about it in the non-dance world. If you create any graphics work, any taglines, anything that you are creating, it belongs to that employer as long as you are the employee and it's in your scope of work that you're doing.
Exactly. I do want to say, we're going to talk about exceptions to this. So when I say employee, I'm talking about a teacher who is paid as a W-2 employee. You are withholding their taxes. You're matching all of the stuff. And this is not we could do another podcast about the distinction between an employee dance teacher and an independent contractor. So we're not here to talk about that today, but I want you to listen for this as employee versus independent contractor. So here's the next part. While you might not owe this dance teacher compensation to use those dances, at our own studio, and I think in the industry, it's always proper to give credit in form of naming that teacher who choreographed the routine in printed programs, performances, competitions, even if you no longer employ that teacher. It's not a requirement if you own the rights, meaning you're the author, but attributing that work is very gracious and it honors those teachers as artists. So we talked about that a little bit when we were compiling this, Jill, right? I mean, it's like good karma.
Yeah, it is. You want to recognize they've worked hard. It's their choreography. They've worked hard to put the time into doing it, placing it, and cleaning it up. So really crediting them and in the programs or even on your website or any type of, I know this, we're going to talk a little bit more about this, but video, if you're putting it out there, you want to make sure that you're crediting the actual person who did that for you.
Right. I would beg to say that most dance teachers think they own the choreography. And this is where it gets complicated and can get messy. And it's not easy to just, maybe this is a part of your employment contract or employment agreement, that you need to make it clear that you understand as part of your job, choreographing routines is part of the scope of work that is work for hire, and we own the routines and we will give you credit for them. But then it goes back to, how do we become the police? As if that teacher walks away, how do we ever know that they don't reuse that choreography? We'll never know. It's
right. Yeah, you're
messy.
hoping they don't, but you need to set the precedent by having that information and those policies in place as the studio owner, because we've seen it so many times. This question comes up a lot. You have a teacher split, she goes to another studio and then, wants to take that with her. So you need the backing and you need to be able to stand firm and say, this belongs to us, this belongs to our studio because this was in your scope of work.
Right. So that leads us to sort of the next part of where does it get more complicated, but these are the points of, if your instructor is an independent contractor, so this could be an independent contractor, meaning you're bringing in a guest artist who is setting pieces, or your teachers are independent contractors, which I'm not here to tell you whether they are or not, but works created by an instructor who is characterized as an independent contractor, a 1099 employee, a 1099 status, may be owned by your studio. So this goes back to, how do you know if you hire that teacher to set a piece and you still want ownership? There's two criteria that have to be met. There has to be a signed written agreement between the hiring party, which is you, and that independent artist, stating that the work that you're paying them for is also a work for hire and it's not owned by them, the independent artist who created it. And number two, this work must be specially ordered or commissioned to use as, and I'm quoting from copyright law, a contribution to a collective work, as part of a motion picture or other audiovisual work, as a translation, as a supplementary work, as a compilation, as an instructional text, as a test, as an answer for a test, or as an atlas. That's broad, but where the dance world falls in is either as a collective work, a part of audiovisual work, or as a compilation. You could technically say, I'm hiring you to do this piece as a work for hire, and it's part of our collective work, call it our recital or what have you. But that independent contractor then has to sign off on an agreement saying that you now are the owner of that.
Right.
Okay?
And I'm sure that's where we have a lot of the studio owners that do a really good job bringing in their master teachers and bringing in those artists. They set the pieces early in the season and then go on and use it afterwards. Or it's those teachers that are there during the whole year. but they're not listed as employees, they're contractors.
Exactly. So lastly, the last part of this complicated matter before we get into even more fun stuff, we consulted with the attorneys from Seafarth Shaw LLP, and they suggested to prevent any future misunderstandings and also protect your studio and teachers who are either hired as employees or independent contractors. They recommend developing a written agreement that clearly states who will own and retain the rights to use, duplicate, distribute, and sell any of the intellectual property created by the contractor or employee in the performance of his or her job duties. So again, consult with your attorney, but they recommend a written agreement of really that there's no confusion of who owns it and who doesn't. There might be a part of you as the studio owner that's like, hey, listen, Miss Sarah, if you want to own that, I'm okay with that. Of which that's when you have to ask yourself, am I paying you to come up with the choreography, or am I paying you to only come into the studio and set the piece that you already did? I don't want to pay you for 10, 20, 50 hours of your time on the floor coming up with these dances. Then you got to go do your work on your own that I'm not paying. And then you come in and you set the piece, and I'm paying you for the setting of the piece. And yes, the creative part that came behind that, but then you can walk away and put that piece on someone else.
Exactly. That's a great clarification. Mm-hmm.
Right. I mean, it's really, it's not an easy water to swim, but I really want you guys listening to this to have some information available to you to at least know where to start. And so that's why we'll link this in the podcast show. But honestly, the groundbreaking part of this was the Martha Graham legal battle that happened back, I don't know, it was probably almost 2 decades ago, but it was Martha versus contemporary, it was her whole contemporary dance works that were who owns the copyright to all of that. So we'll link the information so you can study that legal battle that happened. And also we have a handy little PDF from the Works Made for Hire under the 1976 Copyright Act, which is worth a review. Again, we're just here to empower you to know a little more about this, because as we navigate the age of digital media and all the sharing of video, and it's just so easy to disseminate information. I will say lastly, when you're copywriting anything, whether you're writing down a book or your actual notes of your choreography, it's good to make a copy of that and date it and put it somewhere that you can refer as a reference. So that's where you want to timestamp, date stamp videos. You want to time and date stamp written works and maybe put them in a file so you just have record of that if you ever needed to prove that you were the original creator of that work.
Yeah, because it does happen. We've seen it before. Somebody gets up on stage and all of a sudden they're seeing choreography that has been either done, circulated before, seen before. Something happens. What can somebody do if they do see a piece that may have been part of their own choreography, or they recognize it as somebody else's?
Gosh, it's so hard. It's like the sinking feeling in your stomach when you're like, why have I seen that before? Why is this? I've talked to some dance teachers or studio owners who have had dance teachers who are straight up copying work they see. And you know what? It's too much energy for us to try to police it. It's better for us to focus our energy on knowing the law, and also knowing what our rights are and where we need to have really empowering conversations with our teachers and our staff and things like that, which kind of leads us to that distinction, Jill, of the line between inspiration and infringement.
Yes, good. So let's talk about that, because it's one thing to be inspired by works, and that's what we all do. We go and we watch different performances. We see them live. We watch them on video on YouTube. And we draw inspiration. That's what we do. We take classes from other teachers and choreographers, and that's good. And that creates our inspiration. But where do we cross the line into infringement, meaning we're using too much of what they've given us?
I know, exactly. And here's the thing, we're an industry fueled by what's popular and what's hot, like from the Disney movies to what's hot on Broadway to what's happening in the movies. And so I don't want to say at my own studio, we're excited by what's popular. But we actually went and we consulted a different attorney. She really focuses on this copyright infringement and helped us get our hands around this. Now, again, we're not here to be the police. We're here to kind of help you know the distinction. So let's talk about dance camps, right? Around this topic.
Yep. Let's give some good examples of what we tend to want to do and maybe what we shouldn't be doing.
Exactly. So should a dance studio owner be concerned about copyright infringement if you run a summer camp called Frozen or Trolls? What considerations should we keep in mind for running a theme that ties right into the success of popular movies? Mm-hmm. So here's some guidance from, her name is Shashan Barsichian. She's an attorney at Full Circle Business Law in California. And she suggested that because so much of the arts draw inspiration from other great works and that we feed off of others' creativity, it's honestly why the community is collaborative, right? We get excited about ideas and sharing. Sometimes we show appreciation for a creator's work through imitation. It's what do they say, Jill? Imitation is the highest form of flattery.
It is.
But it doesn't feel that way when you're the one that came up with the idea. Right. So, it's tempting to capture the attention of your young students with themes modeled after these popular movies and characters, especially Disney. From the music, the costumes, the personalities, they are infectious and they make fantastic dance camp themes and motifs. But we have to be cautious and consider the risks associated with using these beloved subjects because copyrights do protect them from misappropriation. So, ready? Inspiration versus infringement. The images of those characters created by Disney or any of these firms are copyrighted. And we have to remember that you really can't use it what is it, Jill? Like you can't use their font. Disney's like specific about their font usage, right? I mean, you can say things to the effect of the music is protected by copyright. And technically they're the ones that are out on stage and can perform, like down Main Street in Disney, they can play the Frozen soundtrack because they own that, right? So because they can perform this copyright music, characters, costumes publicly. So we have to get into what does performing publicly mean when if you take this work and perform publicly. Okay, this is not our rules, this is the rules of copyright. What does perform publicly really mean? According to the copyright law of the US, it says, to perform or display a work publicly means, number one, to perform or display it at a place open to the public or at any place where a substantial number of persons outside of a normal circle of family and its social acquaintances gathered, or two, to transmit or otherwise communicate a performance or display of the work to a place specified by clause number one or to the public by means of a device or process, whether the members of the public capable of receiving the performance or display receive it in the same place or in separate places at the same time or at different times. That's like distribution, recording it and replaying it. In other words, when you play copyrighted music, which is essentially all music that's not in the public domain for your dance camp or participants in your end of season recital, you are in fact very likely performing the work publicly. Although many of us think our fellow dancers and students are family, it's doubtful that a court would see it this way. So that's where it gets tricky, right? Because I would say, oh, they're just private. Like these are people that know our families. However, your options are get permission / the license to use the work or find an exemption or defense to the rule, i.e. fair use or public domain. Unless you can confidently determine that your use of the copyright work is fair use, then the safer of the two options is getting permission, which I'm going to talk about in a second.
Yeah, we're going to talk about how to get that permission.
Which I also want to talk about, you've got to also talk about music licensing. This is paying up your ASCAP fees, BMI, and CSAC licenses. Just because you paid for the download on iTunes does not mean you can use that music publicly. This is why we have to be in compliance with the music. That's a whole other podcast.
Right. Because we see that question all the time. Is this a scam? Do I really need to pay this? Yes, you do.
So I go back and we're going to talk about how I had to give you the facts up front, and then we're going to talk about how we're able to properly attribute. This goes back to the beginning of this podcast. You can do something with integrity if you're attributing. So we're going to talk about this in one sec. So here we go. Dancing to the most popular Disney songs can be one of the most fun aspects of a dance camp. But instructors should remember that performing the music publicly may amount to copyright infringement. You can err on the side of caution and do some research. Is it currently protected by copyright? Would your use qualify as fair use? Could you get permission to use the song? If you can answer these questions before moving forward, you'll know how to make an informed decision. And of course, always ask an attorney. Here's where I would say we're okay, right? Let's talk about where we're okay.
Right, because I think we don't want anybody to be scared and not be able to run these great, popular, money-making camps.
Exactly.
Sure.
Inspired by Disney's Frozen. You know what I mean? You can start to add, we did this with a playlist, right, Jill? We call it Inspired By.
Right. We called it Winter Wonderland or something, but it was inspired by Disney's Frozen. Mm-hmm.
You know, if you can just modify it as inspired by, you know, the XYZ movie, it also is safe to say that unless you're duplicating word for word down to, like, I'll use my daughter's, performing theater company. When they use a script for these actual plays, they have to go pay for the rights. That's when that's when it makes sense to have the theater license with the books for the fair use of it, because you're using it down to the script.
Word for word, exactly.
Word for word. Everybody who's ever done a show like that knows you can go get the rights to it, you pay the money for it, and you can use it. The gray area for us is all these dance camps or, recital themes. No problem. Inspired by, and again, always check with your attorney, but it's good to know what the rules are so that then you can know how. Otherwise, our whole industry wouldn't survive. I mean, think about it. Our whole industry is modeled after inspiration from other shows. Every Broadway show. I mean, think about it, right, Jill?
Right. Yeah. And you want to make sure, too, going one step further, as you're advertising these camps and you're putting things out there, that you're not using the exact Disney font, logo, characters. You can use the same color scheme. You can use the same look and feel, but be very careful. We don't see it happen often, but we have had people lots of times they come after them for copyright infringement. So just be very careful as you're advertising these inspired by camps that you are using the same theme and look that really portrays your theme that you're using and the inspiration that you want to put out there, but you're not specifically using those Disney fonts, those Disney logos, or, Star Wars is real popular now, things like that.
I know, and I'm guilty. Listen, before I knew these rules, we made the same mistakes at our studio. We have it's honestly never usually a malicious intent. It's usually a very innocent use of a Google image search. Nobody here is doing anything intentionally harmful. That's not what we're saying. I think it's just really good for us as an industry to be informed of copyright law, fair usage, paying your music license fees, knowing about the distinction between independent contractors and employees, and starting to have those conversations will help us keep allowing the industry, all of it, music and theater. We want those industries to carry on, and we will continue to be inspired. So I hope this podcast, I'm sure people will probably have follow-up questions. We'll give them links to it, those articles we referenced. But, Jill, is there anything else you want to say when we wrap up in terms of why or how they could use this information?
Well, I think the more empowered you are, whether it be something like this copyright law or any type of information that you can as the studio owner, you have to empower yourself. You have to be inspired to do the right thing, giving credit where credit is due, making sure that you're paying your licensing fees. These are all part of being a business owner, being a savvy business owner. So I think the more education you have, I know this topic is tough, it's dry, there's a lot of words, there's a lot of law that's behind all this. It is important to know, just get through it, understand that you have to do these things as a business owner and as a studio owner. So it is an important topic. It's a little bit tough to really gnaw through and wonder where that gray line is. Are you crossing the line into infringement as opposed to just inspiration or using something that you shouldn't be using? So it's empowering. Take it as it's kind of like taking your medicine. These are the things that we have to do. It's like paying taxes, right? Making sure we're in compliance.
Exactly. Mm-hmm. Good. Awesome. Well, we hope, as always, that this helps you keep your passion for dance alive as you run and grow your business. And until next time, thanks a million for being here. We appreciate you guys.
Thanks for listening to this episode of Dance Studio 411. Visit us online at dancestudio411.com for more great resources and to submit a question for a future episode. Our number one goal is to help you build a successful dance studio business and keep your passion for dance alive.